is Hanujana. My group will present to you about the employer liability insurance. This employer liability insurance is a policy that protects employers who is a person or organization that employ people from financial loss if a worker has injury or illness until death in job related that are not covered by Worker Compensation Act or Social Security Organization (SOCSO), known as Employment Practice Liability Insurance (EPLI). This policy indemnify the employers against liability at law to pay compensation, costs and expenses to your employees arising out of or in the course of employment. The standard common law limit for this policy is Rm ringgit Malaysia 1 million and any in one accident or in the aggregate.
Assalamualaikum. My name is Muhammad Hazim bin Muhammad Shazili and I'm from class BA 2414B and I'm representing my employer's liability group. So, to go further with this employer's liability insurance, we decided to compare the existing policies from Malaysia itself, which is we choose Etika Employer's Liability and QBE Employer's Liability. Okay, so first, let's look on the differences of the coverage between Etika policy and QBE policies. Okay, so from here we can see huge difference can be seen from the coverage of the policy, where so Etika and QBE both stated that if any person under the contract service with insured shall sustain under contract of service with the insured shall sustain bodily injury by accidents or diseases caused during the period of insurance in the course of employment. So here we can see that both of the companies stated what is important for the coverage, so it can be said as the same. Okay, next let's focus on the exclusions of both of the policies. So both policies clearly stated that they will not be liable under the policy in respect of liability to contractors' employees, independent agreement, recovery employment, outside the situation, workmen compensation law, war and nuclear radiation, and others. Differences between the policies can be seen where QBE's policy seems to have a neater and more detailed explanations rather than Etika policies where they just put full explanation where it can be hard for others to understand. Okay, next we will focus on the conditions. Huge difference can be seen here between the policies, where QBE's policy seems to be easier to understand as they have divided between general conditions and claim conditions, whereas Etika's policy, it only states condition as a whole and the explanation is too long and complex, so it will be hard for normal people to understand. So finally, I will talk about the differences of the clauses. A huge difference can be seen between Etika's and QBE's policy. Clearly, Etika have included explanations about clauses, whereas QBE do not put any clauses explanation in their policies. So based on this comparison, we can say that Etika probably provide more information than QBE's employer's policy. Other than that, Etika Employer Liability also divided the explanation of clauses into two categories, which are clauses of endorsement and warranties that are applicable to their policies, and clauses, endorsement and warranties that are applicable to the policy if specified in the schedule. Okay, so with this comparison, we will have a clearer view on how important is the employer liability insurance policy and how the insurance company should structure it to make sure that it can be easily understand to the normal people, which is the company or the employer itself. So that's all from me. Thank you very much.
Hi, my name is Anis Farzan binti Muhammad Fazil. So I will proceed on the explanation of the case under employer liability insurance. So the first case that I will explain is Iqbal versus London Transport Executive. So I will briefly explain on the summary of the case first. So this case happened in the year of 1973, whereby a claim for damages was brought by the plaintiff, which is Mr. Iqbal, and he was employed under London Transport Executive as a bus conductor. So in this case, there was an accident happen where the plaintiff suffered an injury because of at the time of the accident, he was standing in front of the bus, and as he was going to take a drive at his normal service, and then he was struck and trapped between his rear of his own bus, and he then sustained injuries. But however, the plaintiff was prohibited for driving the bus, as in fact he disobeyed his employer instruction for not driving the bus. So in discussion of this case is that the issue here arises whether the plaintiff can be held to have been acting within his scope of his employment, and whether the employer London Transport Executive can be held liable for the injury that has caused to them. So the law that applicable for this case can be referred under employer liability insurance, where it involves employer vicarious liability for an employee negligence act. So this policy is designed to protect the insured employee against risk the common law for injuries or any serious diseases that contracted by the employee. So in application of this case, the plaintiff does not have any connection with his nature of work, for which his action was not employed by the employer to drive the bus or move the bus at all. So in short, the employer was vicariously liable if the employees breach a rule about the way in which they do their jobs, but they are liable if the employees breach a rule about the scope of the job itself. To conclude the overall case, the employer was held to be not liable because the plaintiff was not authorized to drive the bus at all times, as he acted out of his scope of employment. In relating with the employer liability insurance, the insurance cover is not extended to the case of injuries affecting the employees which has no connection to his nature of work. And for the injuries to be covered, the injuries must be causally linked to the employment of the affected employee. So that's all for the case. Thank you.
Hi, my name is Muhammad Yusufi Shamsuddin bin Sofian, and I will discuss with you about case Intel Corporation versus DOR. The fact that an employer provided a counseling services was not sufficient to discharge its duty of care towards an employee suffering from work-related stress. The fact is, Mrs. Dorr worked for Intel from 1988. She suffered postnatal depression after the birth of both of her two children in 1995 and 1998 and was absent from work. She was promoted in May 2000 and her workload increased considerably. Between November 2000 and March 2001, she discussed her workload with her employer, and two additional members of staff were employed, but neither of them was of much help. In March 2001, Mrs. Dawes' manager found her in tears. He asked her to write down what the problems were, which she did. She referred to being stressed out and to her previous postnatal depression. However, her workload was not reduced. She referred to her excessive hours again at her performance review in April 2001. In June 2001, she was signed off with depression. She brought a claim for negligence against Intel, her employer. The Court of Appeal upheld the High Court's findings The court held that although the Court of Appeal in Hatton stated that an employer which offers a counselling service is unlikely to be found to be in breach of duty, this was not a panacea by which employers can discharge the duty of care. In this case, only management was in a position to improve Mrs. Daw's situation. The court also said that Mrs. Daw should not be criticized for remaining in her job and that there is no rule of law which provides that the employer is discharged from his duty of care where the employee does not resign when under stress at work. Intel Corporation versus Daw. We can relate it with employers' liability insurance. Employers' liability insurance, sometimes known as employment practices liability insurance, protects employers from financial loss if a worker has a job-related injury or illness not covered by workers' compensation. Employers' liability insurance can be packaged with workers' compensation insurance to further protect companies against the costs associated with workplace injuries, illness, and death. From the case above, we know that the work overload is the main cause of the stress suffered by the plaintiff, which is Daw. It came from the employer that put all the load to only a person, while actually the task can be distributed to all the employers, to another employees. Stress and pressure suffered by the plaintiff caused loss and damage to her health, which is depression. And the compensation must be paid by the defendant under the liability insurance coverage. That's all. Thank you.
Hi, Assalamualaikum. Today I would like to present to you about the real cases under this topic, which is Ravindran Anak-Lelaki Penjemputan versus Tenaga Nasional Berhad 1984. So the synopsis of the case, which is the plaintiff was assigned to done his duty as a surveyor at the site work building owned by the defendant and his partner Hindai, which is at the block C level 148. As he halfway up using a ladder to level 148.C, a piece of plywood that has been used for construction homework struck the plaintiff, causing him falling off the ladder and suffered form injuries. For that consequences, the plaintiff filed a suit against the defendant, alleging negligence and claiming for special and general damage. There are two primary issues arise for this case, which is whether the defendant as the owner of the project was vicariously liable or whether the defendant was in law and occupier and if so was liable for negligence. So the first issue is whether the defendant as the owner of the project was vicariously liable. At that time, when the incident happened, there are none of the defendant's workers were involved, and straight away that we can say that the defendant is not secondarily liable on the first issue, and this fact was confirmed by the plaintiff himself. For the second issue, whether the defendant was in law and expired, and if so, was liable for negligence. In this case, TMB and his partner has control over the site work. Even TMB does not have full degree of control for the site, but according to the charge, in order to be an occupier, it is not necessary for a person to have entire control over the premises. Therefore, TMB and also his partner, Hyundai, must make sure that every person that enters to their site work, including their employer and any other person, in a safe place, and they have to take care of their duty towards them. As the defendant was liable for negligence, the plaintiff has claimed the defendant does not construct scaffold around the ladder before the accident occurred, but the scaffold was constructed only after the incident happened. So shows that TMB has been negligent toward his employer and also person that came into their site work. So TMB will not be negligent if they constructing the scaffold around the ladder at the first place. So the conclusion of the case, TMB was liable for negligence and had to pay Ravindran for special damage, peace trial loss, and any loss of future earnings, pain, suffering, and loss of immunity. That's all for me. Thank you.
From the discussion, we know that employer liability insurance intended to provide an employer with the compensation for your legal liability and the cost of claimant for bodily injury and illness to your employees resulting from the during their employment. This policy assists in ensuring your business financial security in the event of an accident involving an employee for whom the employer could be held liable can cause the insurance in an immense part of today life where it becomes necessary.